Evening, Attorney Jimena. Good evening, classmates. I am Laurice Justiniani. I am tasked to report Chapter 5, The Lawyer's Duties to Court. The first part of Chapter 5 talks about the lawyer and the courts. A lawyer owes candor, fairness, and good faith to the court. A lawyer is, first and foremost, an officer of the court. Accordingly, should there be a conflict between his duty to his client and that to the court, he should resolve the conflict against the former and in favor of the latter, his primary responsibility being to uphold the cause of justice. Candor in all his dealings is of the very essence of honorable membership in the legal profession. It requires that a lawyer act with the highest standards of truthfulness, fair play, and nobility in the conduct of litigation and in his relations with his client, the opposing party, and his counsel, and the court before which he pleads his client's cause. Based on rulings from the Code of Professional Responsibility, promulgated June 21, 1988, Rule 10.01 says, "A lawyer shall not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice." Rule 10.02, "A lawyer shall not knowingly misquote or misrepresent the contents of a paper, the language or the argument of opposing counsel, or the text of a decision or authority, or knowingly cite as law a provision already rendered inoperative by repeal or amendment, or assert as fact that which has not been proved." Rule 10.03, "A lawyer shall observe the rules of procedure and shall not misuse them to defeat the ends of justice." A lawyer should not conceal the truth from the court, nor mislead the court in any manner, no matter how demanding his duties to his clients may be. His duties to his client should yield to his duty to deal candidly with the court, for no client is entitled to receive from the lawyer any service involving dishonesty to the courts. The legal profession demands that lawyers thoroughly go over pleadings, motions, and other documents dictated or prepared by them, typed or transcribed by their secretaries or clerks, before filing them with the court. If a client is bound by the acts of his counsel, with more reason should counsel be bound by the acts of his secretary, who merely follows his orders. Filing of multiple petitions regarding the same subject matter constitutes abuse of the court's processes and improper conduct that tends to obstruct and degrade the administration of justice. A deliberate misreading or misinterpretation of the law by a lawyer also falls under the injunction and puts him in public distrust. A lawyer should not abuse his right of recourse to the courts for the purpose of arguing a cause that had been repeatedly rebuffed. Based on the Code of Professional Responsibility, Canon 11 says that a lawyer shall observe and maintain the respect due to the courts and to judicial officers, and should insist on similar conduct by others. Observing respect due to the courts means that a lawyer should, number one, conduct himself toward judges with courtesy everyone is entitled to expect. Two, with the propriety and dignity required by the courts. A lawyer who dresses improperly may be cited with contempt. Rule 11.01 of the Code of Professional Responsibility. A lawyer shall appear in court properly attired. Respect begins with a lawyer's outward physical appearance in court. Sloppy or informal attire adversely reflects on the lawyer and demeans the dignity and solemnity of court proceedings. Rule 11.02. A lawyer shall punctually appear at court hearings. Inexcusable absence from or repeated tardiness in attending a pre-trial or hearing may subject the lawyer to disciplinary action as his actions show disrespect to the court and are therefore considered contemptuous behavior. Rule 11.03. A lawyer shall abstain from scandalous, offensive, or menacing language or behavior before the courts. A lawyer's language should be forceful but dignified, emphatic but respectful, as befitting an advocate, and in keeping with the dignity of the legal profession. Rule 11.04. A lawyer shall not attribute to a judge motives not supported by the record or have no materiality to the case. The rule allows such criticism so long as it is supported by the record or it is material to the case. A lawyer's right to criticize the acts of courts and judges in a proper and respectful way and through legitimate channels is well recognized. The cardinal condition of all such criticism is that it shall be bona fide and shall not spill over the wall of decency and propriety. Rule 11.05. A lawyer shall submit grievances against a judge to the proper authorities only. The duty to respect does not preclude a lawyer from filing administrative complaints against erring judges or from acting as counsel for clients who have legitimate grievances against them. The lawyer shall not file an administrative case until he has exhausted judicial remedies, which results in a finding that the judge has gravely erred. A lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. Rule 12.01. A lawyer shall not appear for trial unless he has adequately prepared himself on the law and the facts of his case, the evidence he will adduce, and the order of its preference. He should also be ready with the original documents for comparison with the copies. Without adequate preparation, the lawyer may not be able to effectively assist the court in the efficient administration of justice. Non-observance of this rule might result in the postponement of the pre-trial or hearing, which would thus entail delay in the early disposition of the case. The judge may consider the client non-suited or in default. The judge may consider the case deemed submitted for decision without client's evidence to his prejudice. Rule 12.02. A lawyer shall not file multiple actions arising from the same cause. Rationale. There is an affirmative duty of a lawyer to check against useless litigations. His signature in every pleading constitutes a certificate by him that to the best of his knowledge there is a good ground to support it, and that it is not to interpose for delay. The willful violation of this rule may subject him to 1. Appropriate disciplinary action, or 2. Render him liable for the cost of litigation. Excessive delay causes hardships. 2. May force parties into unfair settlement. Or 3. Nurture a sense of injustice and breed cynicism about the administration of justice. What is forum shopping? Forum shopping is going from one court to another in the hope of securing a favorable relief in one court, which another court has denied. Another meaning is that filing repetitious suits or proceeding in different courts concerning the same subject matter after one court has decided a suit with finality. Another meaning is that filing a similar case in a judicial court after receiving an unfavorable judgment from an administrative tribunal. There is forum shopping where there are identity of parties or interests represented, rights asserted, and relief sought in different tribunals. Rule 12.03. A lawyer shall not, after obtaining extensions of time to file pleadings, memoranda, or briefs, let the period lapse without submitting the same or offering an explanation for his failure to do so. The court censures the practice of counsel who secures repeated extensions of time to file their pleadings and thereafter simply let the period lapse without submitting the pleading on even an explanation or manifestation of their failure to do so. There exists a breach of duty not only to the court but also to the client. An attorney is bound to protect his client's interests to the best of his ability and with utmost diligence. A failure to file brief for his client certainly constitutes an excusable negligence on his part. Rule 12.04. A lawyer shall not unduly delay a case, impede the execution of a judgment, or misuse court processes. It is one thing to exert to the utmost one's ability to protect the interests of one's client. It is quite another thing to delay, if not defeat, the recovery of what is justly due and demandable due to the misleading acts of a lawyer. The law makes it the lawyer's duty to delay no man for money or malice. Rule 12.05. A lawyer shall refrain from talking to his witness during a break or recess in the trial, while the witness is still under examination. Rationally, the purpose is to prevent the suspicion that he is coaching the witness what to say during the resumption of the examination, to uphold and maintain fair play with the other party, and to prevent the examining lawyer from being tempted to coach his own witness to suit his purpose. Rule 12.06. A lawyer shall not knowingly assist a witness to misrepresent himself or to impersonate another. Article 184 of the Revised Penal Code. The lawyer who presented a witness knowing him to be a false witness is criminally liable for offering false testimony is evidence cell. The lawyer is both criminally and administratively liable. Rule 12.07. A lawyer shall not abuse, browbeat, or harass a witness, nor needlessly inconvenience him. Rule 12.08. A lawyer shall avoid testifying in behalf of his client except on formal matters such as the mailing, authentication, or custody of an instrument and the like, or on substantial matters in cases where his testimony is essential to the ends of justice, in which event he must, during his testimony, entrust the trial of the case to another counsel. Rationally, the underlying reason for the impropriety of a lawyer acting in such dual capacity lies in the difference between the function of a witness and that of an advocate. Function of a witness, that is to tell the facts as he recalls them in to answer the questions. Function of an advocate is that of a partisan. A lawyer shall rely upon the merits of his cause and refrain from any impropriety which tends to influence or gives the appearance of influencing the court. Rule 13.01. A lawyer shall not extend extraordinary attention or hospitality to, nor seek opportunity for cultivating familiarity with judges. Code of Professional Ethics Canon 3 says a lawyer should avoid marked attention and unusual hospitality to a judge, uncalled for by the personal relations of the parties, because they subject him and the judge to misconceptions of motives. Rule 13.02. A lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. Rule 13.03. A lawyer shall not brook or invite interference by another branch or agency of the government in the normal course of judicial proceedings. The judge has the corresponding duty not to convey or permit others to convey the impression that they are in a special position to influence the judge. Discussing cases with the judge privately should be avoided. Test when public statement is contemptuous, the character of the act done, and its direct tendency to prevent and obstruct the discharge of official duty. To warrant a finding of prejudicial publicity, there must be an allegation and proof that judges have been unduly influenced, not simply that they might be by the barrage of publicity. Lawyer is equally guilty as the client if he induces the latter to cause the publicity.